My name is John Kelly. This is Chapter 5 of a 7-part series on vulnerable adult. I'm doing these chapters to discuss the legal implications and how to help your family members if they're going through this. I'm going to go into Chapter 5 here and damages. And this is going to go over putting a number on harm without putting a price on the dignity. If you're watching this, you may be wrestling with an uncomfortable question. What does this case mean in dollars? In this chapter, we'll talk about how damages work in vulnerable adult abuse and neglect cases, economic losses, non-economic harm, and the themes that tend to drive high-value outcomes. As an attorney, I'm here to help you understand and navigate what can feel like an overwhelming situation. So this is going to be the dollars and cents part of the journey. And although it's an emotional journey all around, at some point we have to talk about the dollars and cents of the situation. And I want to say something right up front, because families often feel guilty when thinking about money. Talking about damages is not greedy. It's not making a big deal. It's not disrespecting the person you love. It's the reality. Because these cases are expensive, the harm is expensive, and the only tool civil law has to respond is compensation. Now, money can't unbreak a hip. It can't erase humiliation. It can't restore a mind lost to delirium and decline. But it can pay for care. It can pay for safety, therapy, and supervision. It can stop the financial bleeding while a family tries to heal. So let's talk about damages in a clean, structured way. Economic damages first, and these are the costs that you can add up. In vulnerable adult cases, economic damages often include the medical bills, the hospital costs, ambulance and emergency care, wound care visits, surgeries for fractures, IV antibiotics for infections, ICU stays for sepsis, rehabilitation and therapy. Increased level of care is going to increase the costs. And this is a big one. Sometimes the resident was in assisted living and now must be moved to a skilled nursing facility. Sometimes they were in skilled nursing and now need memory care or hospice. Sometimes they need one-on-one supervision, private sitters, or someone because they are now too unsafe to be alone. Sometimes the family takes them home and the family becomes the staff. Those changes cost money and they're out-of-pocket expenses. So some of the other out-of-pocket expenses in economic damages include medical supplies. So we're talking about special mattresses or support surfaces, mobility devices, transportation, home modifications in the residential home. In wrongful death cases, economic damages may include funeral and burial costs, final medical expenses, and sometimes the value of services the person provided, depending on the law of the state. Now, as an attorney, I know the economic damages are only half of the story, sometimes less, because the heart of these cases is really the non-economic harm. So what's important to understand is the non-economic damages, and this is the harm that doesn't come with receipts. Non-economic damages can include the pain, the pressure injuries, the hurt, the fractures, the aspiration that hurts, the sepsis hurts, and the end-of-life context. Suffering is not theoretical, it is lived. Emotional suffering and fear. Imagine being confused, in pain, unable to have final words, and dependent on strangers. Imagine being left in the wet bed. Imagine being rushed and handled roughly, mocked, or ignored. That fear counts as damages. We also have non-economic damages that include loss of enjoyment of life. Even in advanced age, people still have joys, often great joys, family visits, their favorite music, sunlight on a patio, dignity during bathing, feeling safe in bed at night. The neglect can steal those small joys first, and those are damages. Loss of dignity. This is one of the most important harms in vulnerable adult cases, and one of the hardest to explain to a jury until you explain it plainly. Dignity is not abstract. Dignity is being clean. Dignity is being listened to. Dignity is not being left on your own to waste. Dignity is not being treated like an inconvenience. When a facility takes a human being and treats them like a task list, that is harm. Another damage is loss of consortium, and this is family impact. Spouses and families often suffer their own losses, watching a loved one in decline, carrying the caregiver burden, living with guilt and anger, and losing the relationship as it was before. Now, in many states, there are rules about who can claim what and how, but the concept is constant. Harm radiates outward. A vulnerable adult case is rarely just the resident. It becomes a family injury. So what are some of the high case value themes? What drives the serious exposure? We can talk about what tends to make these cases a high value, because if you're like me, you need to spot these themes early, and if you're a family member, you deserve to know why some cases create more leverage than others. So the first theme we'll talk about, deep pressure injuries, especially when infected. A stage 3 or stage 4 pressure injury, especially if there is an infection, sepsis, and hospitalization, and these often create signals that we see of prolonged neglect and system failure. It's not just the wound, it's what the wound represents. And that's what drives the damages of missed repositioning, missed skin checks, missed hygiene, missed nutrition, missed escalation. The second theme that we'll talk about is malnutrition and dehydration with documented weight loss. When a resident loses significant weight and develops repeated infections, becomes lethargic, and then crashes, the defense can try to call it a decline. But a documented weight loss trend is a measurable story. It is neglect that can be graphed. Another theme that we can talk about is medication, over-sedation, and falls. When a facility uses medication as a substitute for staffing, and the resident then falls or aspirates, the jury understands the moral math. They choose convenience over safety. The fourth theme, resident-on-resident violence with known prior incidents. If there were prior incidents and the facility did not change supervision, room placement, or staffing, then the harm is not unexpected. It's foreseeable. We'll talk about the fifth theme, elopement, especially with serious injury or death, are often a high case value because the public intuitively understands a locked memory care unit is supposed to prevent wandering out. If a person walks out, systems have failed. Another theme 6, is sexual assault. Sexual assault in a care setting is one of the most devastating violations imaginable. These cases often involve profound non-economic damages, and they can open doors to punitive exposure and system claims about hiring screening, the supervision that they had, and reporting failures. Theme 7 for damages is wrongful death with clear chain. When the case narrative is clean, failure to turn leads to pressure injury, leads to infection, leads to sepsis and death. It can become a powerful story of preventable suffering. Now let's talk about a hard defense argument you'll hear. They were old, they were sick, they didn't have much time left. But here's the truth. The value of human life is not measured in remaining years alone. A vulnerable adult still has a right to comfort, safety, and dignity. If a facility causes a preventable, painful injury, the law does not excuse it because the person was 88 instead of 28. And juries will understand that deeply. They may not talk about the statutes. They talk about decency, about what we owe each other when someone can't fend for themselves. So I'll go over the damage modeling that we do and how we present it to juries. In a serious case, we often use a life care plan or a similar framework, even when the resident is older, because the question is, what did this harm change? Did it increase the level of care? Did it shorten the life? Did it introduce a new pain and suffering? Did it require wound care, surgeries, or long-term antibiotics? Did it require a move, a private sitter, a different facility, or hospice earlier than expected? The expert in economics may provide future care costs. Medical experts may testify about the course of pressure wounds or fracture outcomes. Families can testify about what changed day to day and really paint the picture in that way. And it really is kind of a storytelling, and it matters as much as the spreadsheets do. A jury can understand before the neglect, mom could walk with help to the dining room and recognized her daughter. After the neglect, she was bedbound in pain and afraid. That is a damages story. Let me give you a brief story example that may strike home with some of you. A man, Mr. Patel, places his wife in a nursing facility after a stroke. She can't walk alone. She has swallowing issues. She is alert. She smiles. She squeezes his hand. He visits every evening. Then his work schedule changes for 2 weeks, and he can only visit on weekends. On a Saturday, he finds his wife with a foul-smelling wound on her sacrum. She is lethargic. She is feverish. The facility says, "Oh, we noticed that recently." At the hospital, she is diagnosed with sepsis. She never returns to her baseline, and within a month, she is on hospice and she dies. When Mr. Patel later hears the word stage 4 pressure injury, he feels something break inside. Not just grief, but betrayal, because his wife didn't die of old age. She died of being left unmoved, unattended, and untreated. That kind of case is not about money as a prize. It's about money as accountability. It's about forcing the system to pay for the harm it caused and sometimes forcing change on the facility. Now, damages also include something less obvious, the cost of carrying this. Families lose sleep. They lose trust. They lose the sense that the world is safe for the people that they love. That is not a line item on a bill, but it is real. Now that we've covered damages, how we quantify harm, and why these cases can be high value, the next chapter is what most families need, because a defense is not passive. In the next chapter, we'll switch perspectives, the defense playbook, and how facilities and insurers try to minimize, deny, delay, and distract. We'll talk about common defenses like inevitable decline, pre-existing conditions, the resident refused care, it was an accident, we were understaffed, and we'll talk about how to counter those arguments cleanly, credibly, and effectively. If you have a loved one who's a vulnerable adult, and after listening to the video, have questions, we handle these cases throughout the nation, and we're happy to consult with you. If you'd like to talk to us, please call us at Kelly Law Team at 602-283-4122.